Interview is part of the History Heard project. The content of this interview may be used for historical research. However, no part of the video itself may be reproduced without the express written permission of an authorized representative of History Heard. Today is July 25th, 2012 at 6 p.m. This is an interview with Mr. Adam Liptak in Washington, D.C. He was born on September 2nd, 1960 in Stamford, Connecticut. A graduate of Yale Law School, Mr. Liptak spent 4 years practicing law with a private firm and then a decade with the legal department of the New York Times Company. In 1992, he moved into the news division of the New York Times and now covers the United States Supreme Court. His writings over the years have appeared in a variety of prestigious publications, and he has been a finalist for the Pulitzer Prize. Mr. Liptak, you spent most of your legal career defending newspapers in cases involving freedom of speech and other important constitutional issues. Many lawyers would say you had the single best job in the entire legal profession, and you gave it up to become a journalist. What led you to make that decision? What goals and motivations carried you?
Well, part of it was that in a way I'd always wanted to be a journalist, but couldn't figure out a way to do it without really paying my dues at local papers and working my way up, so I came in sideways. But in the back of my mind, although in a kind of a dream sense, it was something I'd always wanted to do. And while I'm open to the idea that that's a great legal job and it's a terrific client and a good cause to fight for, being a lawyer isn't nearly as much fun as being a journalist. Being a journalist is much more fast-paced, much more general. You can satisfy your curiosity in a lot of ways, and being a lawyer is one fight at a time, and not always about big deal things.
Tell us a little bit about your current job. Do your days differ greatly depending on whether the Supreme Court is in session or not?
Very much so. The Supreme Court is not an especially hard-working court. It's in session from October to June. It takes the summers off. As Chief Justice Roberts, when he was a young lawyer, said, only Supreme Court justices and school children get the summer off. When the court is working, it tends to concentrate its work on a few days a month. It hears arguments maybe 6 days a month, and on those days it often also issues decisions and also issues orders about cases that they're going to hear or not hear. So the work tends to be very concentrated, and the rest of the work is preparation. So in order to be good on the days when you really have to be ready to write fast, you have to do a lot of preparation work.
And do you ever communicate directly with the justices?
I have interactions with them. Cordial ones, but not ones that really go to substance. You know, the courthouse is a small community. You run into people. There are occasional off-the-record lunches, and when I started at the court, I went and sat with most of the justices. But I wouldn't stress that that's journalistically useful. It's just a kind of courtesy that members of the same community, kind of engaged in doing the same thing, might want to be in touch.
As a former practicing attorney, now covering the Supreme Court, you know far more than a lot of court lawyers. What do you think about the caliber of lawyers arguing before the court? Have you ever seen some clear and appalling blunders?
The Supreme Court bar, there are maybe a couple dozen people who argue regularly before the court, are exceptional lawyers. The quality of the briefing in general and the quality of oral advocacy in general at the court is very, very high. Once in a while you have somebody who handled the case at trial, handled the appeal, and thinks that it's fine to come into this really quite different world and argue their case. And occasionally that works out great, but not infrequently that person doesn't really have a sense of how to communicate all of a sudden to 9 justices who aren't concerned so much with the right result in the particular case, who should win or lose in the particular case, but in trying to figure out what rule of law should be generally applicable in thousands of cases. And that, plus figuring out how to get 5 people who have conflicting ideas about the case to agree with your point of view, that's a real art, and that's something that not every new lawyer can master. And that's why, in general, the established Supreme Court bar, who argues all the time, a lawyer named Paul Clement, who argued the healthcare case, argued 9 times this last term, those people do, in general, a very good job.
Okay, and then do you ever put yourself in their position and kind of picture yourself presenting the case and how you would have done it differently?
In a nightmare, perhaps. I argued the occasional appeal when I practiced, but not at that level. That would be. I could imagine writing a brief. I wrote a few Supreme Court briefs while I practiced, but actually arguing before the court, I think the wise thing would be to hand it off to a pro.
Okay. And then you write about complex technical legal issues in a newspaper with a general audience. How do you deal with that challenge?
That's the biggest challenge of the job, is to translate and end on deadline, as you say, these technical matters. And what you need to do is to find a conversational tone that's direct and accessible, but that doesn't lose accuracy. And that's a judgment call, and it's over time you find ways to take bits of jargon and find satisfactory regular English phrases that you can translate them into, and it's a little bit of trial and error. I get a lot of feedback from readers. It's very enthusiastic, somewhat pedantic readers I have. And over time you kind of figure out how to do it. And I've only done it for 4 years, but the court looks at the same issues over and over again. So there's a certain amount where you can look back and just ask, how did I handle this last time? It seemed to work out last time. Maybe I'll do it that way again.
And as you said, healthcare has been a recent and controversial issue. Can you explain the court's recent decision on President Obama's signature healthcare legislation and some of the decision's implications?
People have called it, and I don't think there's a lot of exaggeration involved, the case of the century. It got much more attention than any case I've been involved in, but I don't know of a case since Bush v. Gore in 2000, which decided a presidential election, that has gotten as much attention from readers, editors, the general public, whatever. The case asked the question of whether the healthcare legislation, which dramatically expanded healthcare coverage and brought the United States into the general world of developed nations of essentially offering health care to everybody, whether that legislation exceeded Congress's power. The Constitution gives the federal Congress only a limited list of powers, and in order to pass legislation, it has to fit within one of those powers. And everyone thought the key question in the case was whether Congress, under its power to regulate interstate commerce, could regulate health care, and in particular through a mechanism called the individual mandate, which required most Americans to either obtain health insurance or pay a penalty. And to the surprise of a lot of people, because it does feel like the regulation of interstate commerce, and it actually, our healthcare market is a huge interstate market, 5 justices of the Supreme Court said no, Congress had exceeded its powers. Under the Commerce Clause, it was unconstitutional. That was not the result anyone expected. And if that's the only result you heard, you would have thought the law had been struck down. But out of nowhere, Chief Justice John Roberts, generally conservative, joins the court's 4 liberal members and says there's a different justification for the law, that it can be conceived of as a tax, and therefore under Congress's power to levy and collect taxes, it could be justified. So that kind of shifting 5-4 dynamic, where the Chief Justice joins the 4 more conservative justices on the one theory, but the more liberals on the other, gets you to what may be the right result, but through a surprising route. I was just reading a nice article the other day. When Chief Justice Roberts was asked at his confirmation hearings what the role of a judge is, he said it's like an umpire. You know, you just call balls and strikes. And this writer said, well, what happened here was that Chief Justice Roberts called a ball a strike, called a strike a ball, but the good news was that the runner was safe.
It's very interesting. This interview is part of the History Heard project. The content of this interview may be used for historical research. However, no part of the video itself may be reproduced without the express written permission of an authorized representative of History Heard. Today is July 25th, 2012 at 6 p.m. This is an interview with Mr. Adam Liptak in Washington, D.C. He was born on September 2nd, 1960 in Stamford, Connecticut. What changes do you see taking place in the court? Some observers contend that because of cases like Gore v. Bush, which gave the presidency to George W. Bush in 2000, Americans today no longer see the court as a basically neutral body, but instead as a collection of individuals who have their own agendas and are no less partisan than any other public official.
That is the general sentiment. Surprisingly, Bush v. Gore didn't cause an enormous disruption in the court's generally high approval rating. The court's approval rating through the years and through and after 2000, when Bush v. Gore was decided, was in the 50s and 60s. Lately, it's dropped very substantially, and partly because, as you say, the court is perceived to be partisan and political. It used to be, for decades and decades and decades, that you couldn't tell how a justice would vote by the party of the president who appointed the justice. So that Justices O'Connor, Stevens, Souter, all appointed by Republicans, and all were moderate to liberal. These days, the 5 Republican-appointed justices are all of them conservative. The 4 Democratic-appointed justices, all liberal. So it plays out and looks partisan. And all the talk around this health care decision, and I don't think the American public pays a lot of attention to the court in general, but all this talk about the health care decision and all the talk in explicitly political terms, I think caused people to lose some respect for the court. So its approval rating dropped to 44% before the decision and down to 41% after the decision, which is still way above Congress, but below the president, and that's unusual.
Thank you very much.